And we are live. I am attorney Justin Sterling, a personal injury and business lawyer. This is Coffee with a Lawyer, streaming live on the digital airwaves of YouTube, Facebook, Instagram, and LinkedIn. This is your chance to ask the lawyer your legal questions for free. This is our pro bono legal service. This is why I do what I do, to help people deal with legal issues, improve their lives, and make a meaningful difference. Please know there is no attorney-client relationship. There is no confidentiality here because we are streaming and there may be other participants. There may be people listening online. The information disclosed here could be discoverable in any legal matter. So it's very important that we keep information general. This is only meant to provide general information and is not specific legal advice. I encourage you to keep the questions general and not be specific. If you need to speak about specific details, it is best to schedule a confidential consultation with a lawyer. And today we have a special guest. So I would like to allow our guests to ask their question. Go ahead and proceed. Yes.
Thank you for having me. So I recently had a case dismissed due to improper service. And I also filed a motion to reinstate the case, which was denied. In the order, it stated that I did not serve properly due to I did not serve both registered mail and personal service. Even though I did get a return of service for the registered mail from the court. And this might be helpful to other people that are using AI tools like ChatGPT, trying to get legal advice, because when I initially asked, what were the requirements for service, it must have read the Court of Rules and stopped where it saw that I could serve them via registered mail. Which ultimately put my case in jeopardy to the point where now it's been dismissed, and I'm going to have to start all over, basically. So with that background, my question is, I am filing a complaint against a state agency in Michigan, the Michigan Lottery, and I originally served to the Michigan Attorney General. I did not serve separately to the Michigan Lottery office, which I think is where I also misstepped. So I didn't do personal service, and I didn't serve the Michigan Lottery separately because research online showed that the Michigan Lottery is an agency underneath the Michigan Attorney General. So that's where I'm at right now. My question is, how do I proceed from here with starting fresh, making sure that I do a proper service?
Okay. Thank you for the question. Thank you for sharing. I'll try my best not to get too much into specifics because I want you to have the protection of confidentiality and privilege, and we're not referencing any personal identifying information here, so that this should not be discoverable. But I am posting my comments, some notes that I took into the chat, okay? And we'll just take it one step at a time here. Okay, the question involves service. I do want to just let it be known that there are different types of service of process. There are different levels of strength. The more strong service, of course, is the personal service by a licensed, registered process server who can draft an affidavit, which is basically a declaration under oath, a witness statement that they file with the court as evidence that, in fact, they gave these legal documents initiating the legal process to this party, and they identify the party, they identify the means of service, and it's strong service. Even as a pro per, I would encourage you to reach out to a registered process server to do this for you, because it's a matter of evidence, and that's a third party independent witness that will support the service. Does that make sense?
Yes, I've since reached out, and I'm ready to use them as I proceed, but I did not, previously, obviously.
I understand. I know hindsight's always 100% correct. But yeah, I would encourage you to do that. And then also serve it by all different means. I mean, the key is to prove that this person has notice of the lawsuit or this entity. Serve it by process server to their registered agent, serve it to their principal place of business, serve it to the main agency, serve it to their sub agency, serve it all over the place. Okay? Don't just say like, oh, I read it on ChatGPT and it said I had to serve this one specific department. Serve it all over the place. Okay?
Okay.
Don't just hold back just because, oh, I thought I met the requirement. Also, I want to backtrack because I know you're in pro per. As a pro per litigant, you have access to the sheriff's department. You can give that complaint and the summons to the sheriff's department and they'll do it for free.
Wow.
Do that and do it with a registered process server. The one thing about accessing the sheriff's department is that they'll take a long time. They're backed up. They're going to take months before they actually serve those legal documents. But you can access the sheriff's department for free. And federal court, I think the U.S. Marshals will do it. Now, I don't know, are you in state court or federal court?
State.
Okay. Now, we're kind of also getting ahead of ourselves because you're talking about an agency, a public entity. And I believe we've spoken about your situation in the past, and I think you have confirmed this.
Correct.
But there are strict time deadlines when you're dealing with public entities, strict notice claim deadlines. 6 months from the incident, you have to give them proper notice of the claim. And it's a specific process. And you have to also send that with track and registered mail and make sure they have it and they have to acknowledge it. And you can only file a lawsuit once they deny your claim. Okay, or it's deemed denied by operation of law if they don't respond within a certain time period. Each jurisdiction is different. I'm licensed in California, so I believe in California it's 6 months or so since after they receive the claim notice. I think you've done that, if I recall correctly. Okay, so we're past that point. So you filed your complaint. Now you want to get it served. Did you say your complaint was dismissed for improper service?
Yes.
So it was
Correct.
in fact dismissed.
Yes.
Okay, I mean, you can appeal that, or I believe you can just file. Was it dismissed with prejudice? You have to look at the dismissal, with or without prejudice. Should be without.
Yeah, I'm looking right now. I'm looking at the order right now.
And I do know we have some people in the chat here viewing, and if you have questions, post it in the chat, and I'll try my best to get to it.
Yes, dismissed without.
Okay. So you can just refile. I mean, forget the appeal process. Just refile it and do it with proper service. And I would encourage you to access a registered process server. It's more strong. And the different levels of service, personal service, of course, is the most strong. That's to them directly. There's also substitute service, which is, for instance, an adult who lives in the home. You serve them and give them notice of the complaint. That's considered substitute service. But you're dealing with an agency here. Just go with the agent for service of process. For a state agency, yes, it could be the attorney general. Depends on what type of agency. It could be, I would serve them directly to the department. Just go to the department and serve it everywhere, so you avoid this discrepancy again in the future. And you can go to the court. Not only did I serve the attorney general, I served them at the office, I served them there. I went through a registered process server. They have notice of this complaint. Yes. So I just wouldn't stop there. And I would go with the professional, the registered process server, because you're having in a pro per as an improper litigant, you're going to be scrutinized. The courts are going to be critical of what you're doing because they don't want all of the citizens to take up their time and resources. So if they can kick out a case that is brought by an improper litigant, they will, by whatever means. If it was insufficient service, they'll kick it out. It saves the court time, energy, and resources. There is the business of justice. The court has to process these cases. And the first chance they can process a case and get it out of their docket, they will. If it's based on service, they will. But don't let them do that to you. Go through the professional means, hire a professional process server. It's not that expensive. A process server, especially to do a public entity, a state agency, because they're not moving. You know, they're not going to be they're not going to be evading justice. It's a state agency. It's an entity. It's an organization. They know where to serve it. It's an easy serve for a process server. You just want to hire the professional for your own protection so you don't get kicked out of court again.
Right. Okay. Thank you.
We do have another guest. Jared, would you like to ask? I'm sorry. Excuse me. I do want to avoid using names here to protect privacy. I apologize. But yeah.
No worries at all. Good morning. Let me get on video.
Yeah, it's fine.
How are you doing, sir?
I'm doing well. I'm doing well. Thank you for signing on. I think you've signed on a few times before in the past, right?
Oh, I believe this is my first time actually appearing.
Okay,
so,
welcome.
Yeah, I love seeing that you've been offering this. So, and I've been meaning to hop on for a while. So.
Well, let me just give one brief disclaimer. I said it earlier. I do have to make this very clear, is that I encourage you to speak generally. Try not to get into specifics, because what we talk about here is not confidential. It's not protected by the attorney. There is no attorney-client relationship, no privilege. And if you are in litigation, if you find yourself to be involved in a lawsuit, what we say here could be discoverable by the other side. So we have to be careful. So let's not reveal any confidential information that could be used against you. I also
really appreciate that disclaimer, and that is noted.
I also want to get into the practice of, you know, I just had a discussion with Stephen, and I don't know if you were able to listen, but, you know, what we talk about here could help many people involved. So if you think that I'm being of service and I'm helping you, it's not required, but I would be really, truly and honored if you leave a positive, kind review.
No, I definitely think this should definitely be shared. I think what you're doing again is awesome.
Appreciate you. But just signing on is enough for me. So how can I be of service?
Yeah, so I had a question. I basically had a tentative ruling, yet didn't actually have the court date yet. And there seems like there's a kind of a big issue with one of the arguments where the judge said the official, so basically there's a lot of deputies, and I also have the sheriff's office and the county. And the judge basically said the official capacity claims against individual defendants are duplicative of claims against the county. And they basically cited the Luke v. Abbott case to the extent the individual defendants are sued in their official capacity, the causes of action are redundant of the claims against the county and the sheriffs, and this defect cannot be cured by amendment.
Mm-hmm.
So that seemed, I thought that was kind of incorrect.
I will say this. At times I may interject, not to be impolite, but to lead the conversation because I'm listening with my legal insight and experience. I will say you to a degree, you may be correct, but generally, the court is correct here. But in your oral argument, you may want to present this to the court. Now, it's a tentative ruling. Very difficult to go against the court's tentative ruling.
Right.
There's a slim chance that you could reverse the court. You could persuade the court. But I would still present this, and it depends on your pleading, your complaint. Review the factual allegations in your complaint, because if you have factual allegations of these individuals that were in some way acting not in their official capacity or overreaching, going beyond their duties, then they could have incurred some negligence on their part, some fault, some wrongdoing, personal liability. Those are some key terms you want to argue. But what is really the benefit of arguing this? The court is correct. If they were acting within their official capacity, they are an agent of I believe it sounds like you're dealing with a police mistreatment case, correct?
Correct.
Okay. You want them acting under color of law so you can hold the police department responsible for the violations of your civil rights. That is an element of, are you in federal court?
No, I'm currently in state court, and that was my other concern, because I wasn't sure if the judge seems very new as a judge, and I wasn't sure because another element is on the tentative that I didn't really address is they're using the 11th Amendment in state court and totally denying me Monell, illegal strip search, and extended detention. And they're applying the Venegas case, and I believe using the incorrect dicta that came from that case. So I'm also in kind of a time where I'm like, do I just try and file a dismissal and then refile in federal court before there's per se bad res judicata from this judge?
That's a nice consideration. It's a thought, because these type of cases are typically brought under Title 42 USC Section 1983 for violations of your civil rights under the federal code. So it's a federal case, right?
Yes.
So it's a consideration. State courts are courts of general jurisdiction. The defendant may have it removed to federal court on that grounds. You may want to consider it. I mean, ultimately, the federal courts hear these cases more often are in a better position to rule on these. There's a lot of considerations. Again, the judge, is your connection with the judge good? You're saying there may be some pushback. You don't feel very confident in the judge. It may be more proper to be brought in federal court. You may want to raise that at the hearing and put it out there. Now, of course, the court is not going to give you an advisory opinion. It's not going to tell you what to do, but sometimes they may say things that point you in the right direction. For instance, the judge may say, sir, I'm not going to give an advisory opinion. I'm not going to tell you what to do, but I do know that this case, if it proceeds, it is apt for a motion for summary judgment and dismissal. So trigger, okay, I better get out of here. Let's work on getting this into federal court. So, I mean, it's a feel. It's a feel. I will say this, police mistreatment cases, the leading attorney in this area is a man by the name of Dale Gallipo. You need to research him. You're in the midst of this. Police brutality, violations of your civil rights, police mistreatment. He is the leading attorney. Even if you cannot get him to represent you, research him, his content, his information he puts out there. He is the leading police mistreatment lawyer in the country. Great lawyer. I've studied him. I've learned under him. He speaks a lot at conventions. He is the leader. It gets very technical with these police mistreatment even unlawful detentions and strip searches, and he's created all that case law, all right? But he gets very technical, you know, when police bring out their weapons, you know, how far did they extend it? Was it down? Was it up? Was it pointing? Did they have the finger on the trigger? It gets very technical. They retain experts, gun safety experts, police training experts. It's a very technical area. My practice is more in general personal injury, general negligence and harms. Dealing against the police is a very niche area. I will say this, though, there is another attorney by the name of Justin Sterling that is also located in Los Angeles who handles police misconduct cases. Now, we often get confused with each other. I mean, I have handled Section 1983 cases in the past, but it's a very specialized niche area. My primary practice area is in general negligence law. But I am a litigator, very trained on these the litigation process, and you do have some litigation issues here in the civil realm, okay, civil procedure. And like I said, it's difficult to go against a tentative ruling. I would have to probably read that ruling to understand exactly what the court is saying. In terms of the duplicate claims, they're right. If they were acting within their official capacity, the proper defendant is the agency. They were acting under color of law as an agent. Does that make sense? But if they did something beyond the bounds within their official duties, you can hold that individual officer personally liable.
Okay. In their individual capacity.
Mm-hmm. Those are some buzzwords you want to throw out there if you do choose to argue against the court's ruling at a hearing. Do you have a hearing date?
Yeah, it's almost like a month away. So
review your complaint, know your factual allegations well, and I'd have to see your causes of action. You may want to have different causes of action. You may want to ask the court for a leave to amend the complaint, because this is what you tell the court, this is what happened. This is what I was trying to convey in my pleadings, in my complaint with the factual allegations. The court may not have reviewed it like this, but I'm asking the court in good faith for the opportunity to amend this so I can get the pleading correct, because this is in fact what happened. Not only was there a violation of under color of law, there was also a personal violation of my rights by this individual, because he went beyond the scope of his duties. And that's where the violation is. There was a violation by the agency under his official duties, under his official capacity, but then he went even further and he went beyond his duties and he violated my rights himself. I'm holding not only the agency liable, but I'm also holding him personally liable. They're all liable. All right. And as a plaintiff, when you plead, when you assert your rights, you don't want to confine yourself. You know, extend the scope of liability. Of course, you want to go against the agency. They're the ones with the means to give you recourse. Even going against an individual, whether they're an officer or a private person, I'm not really so much in the business of going after individuals, even if they do have a lot of assets. Not likely you're ever going to get a recovery. It's difficult to get recoveries from individuals. And that's justice in our society. I mean, we cannot reverse the clocks of time and put you realistically in the place where you had not been harmed. It's impossible. It's against the laws of reality. It's not going to happen. But our civil justice system tries to do our best by awarding monetary compensation. And so as an attorney, when I evaluate things, I got to find out, where's the recourse? Where can I get you justice, compensation? Understood?
most certainly, I really do appreciate your perspective and insight.
Is there any other questions? I mean, I'll say this. I don't know when your hearing is, but legal cases take twists and turns. There's no way to tell really how this judge will decide after you lay out your argument. But keep checking back because it progresses. It's something you have to build. So this is a great place to tap into the source of some insight. Again, the police misconduct cases are not my main area of practice, but at least this is a place where you can just tap into and focus yourself, because legal issues are important. They have to take priority. That's why we have this meeting every Monday morning, 9 a.m., first thing of the week, so you can set your priorities and attack them for the week ahead. And then check back next week and let's discuss what you did well, what you need to continue to do to be successful with your legal matter, and what you could do better. This is a great place to keep yourself accountable. Even though I may not be your retained legal representative, this is a place where you can stay accountable for your own legal issue. Sound fair?
Most certainly.
Okay.
Definitely will be back.
All right, well, I appreciate you. Again, although it's not required, I would be truly honored and grateful if you guys were to leave a positive, kind review. I will put the link in the chat. Let me see here. Let me put it on the chat here. And if you could, click on it before you guys sign off, because it does disappear once we log off Zoom. But again, not required. I would just be really grateful and honored. And what's more important is that I can be of service and you keep checking in. And that's what's most important. I hope you got something out of this. We like to keep these meetings relatively short. We're about half past the hour. Any last questions before we adjourn? Okay. All right. If we're good here, let me check the chat to see if we have any questions in the chat. I know we have some people viewing. I want to say thank you to those online. I want to say take care, take action. More will be revealed. Please keep tapping in, and to be continued. Thank you. Have a good rest of your week.